All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So I'm going to start today with four really quick hits, four arguments that discrimination attorneys and HR should be keeping their eye on this coming month. The first involves a case with FedEx. They are seeking to knock down or reverse, get this, a $366 million verdict from a Texas federal jury that awarded a former FedEx sales manager, one plaintiff, in her case that she alleged the company sent her or fired her because she filed complaints of race discrimination.
At the tail end, 366 million?
At the tail end of a 2022 case, a Texas federal jury sided with the plaintiff and awarded her $365 million in punitive damages, as well as some other damages, $120,000 for pain and suffering, and $1 million for future medical damages. And so
she'll need that extra $1 million, that would be important. Yeah.
Yep. So FedEx is obviously appealing that case, and the arguments, I believe, in that case are going to be held this month. Next one has to do with the EEOC trying to revive a disability suit over mask mandates. We're going to go all the way back to March of 2020. The EEOC brought a lawsuit under the ADA on behalf of a former employee of a pharmacy in Texas who was fired or sent home by the store manager in March 2020 because he wore a mask to mitigate the risk of the then burgeoning COVID-19 pandemic. Ultimately, that court granted summary judgment for the employer, saying that the incident was a one-off and that the Fifth Circuit standard for bringing a harassment claim requires more than this single incident of sending somebody home. And so the plaintiff in that case is appealing that one. Another one to keep an eye on is out in the 11th or over in the 11th Circuit. This one has to do with the transgender man who said he was purposefully and mockingly misgendered on a daily basis by supervisors and coworkers at the Georgia Department of Corrections. In this case, the individual transitioned in and then in mid-2020 filed a lawsuit because Human Resources instructed other personnel to adjust how they refer to him, but that most of his coworkers ignored that directive. So this one really gets at the issue here. The incidents were daily and purposeful, according to the plaintiff, because they were often accompanied by laughter at the plaintiff's expense. One coworker even referred to the plaintiff as it and that. A female coworker told the plaintiff she was proud to be a woman and threatened him physically. So that case is going to be one to keep an eye on. And then another one out of the 10th Circuit that I think is really interesting is in this case, a white former sergeant in the Colorado Department of Corrections will challenge a trial court's dismissal of his suit, alleging that workplace diversity, equity, and inclusion training violated civil rights law. According to the plaintiff in that case, the training created a racially hostile work environment against white employees. The Department of Corrections in Colorado argued that the plaintiff hadn't alleged any actual instances of harassing behavior, and that his disagreement with the DE&I seminar doesn't make it harassment. The plaintiff in that case responds by saying after he attended the training, he sensed that the colleagues viewed him as racist due to his status as a Caucasian individual. So just a slew of cases to kind of keep your eye on this month that are important in the area of labor and employment law, as we all try to figure out as labor and employment lawyers and as HR what the boundaries are of these very, very hot issues.
Yeah, I think there are several very interesting things to discuss there. But if I go back to the transgender male situation who was continuously referred to maybe harassingly by his coworkers, that's a tough one that I think people face probably every day when it comes to how someone wants to be preferred or chooses to be preferred. whether they've gone through, a transgender change or not, I can see where that could get sticky. If I want to be referred as she or her and you choose not to, or you mock me, whether I've been through transgender change or not, that could cause some problems.
Yeah, I agree. And it's, we're kind of waiting for the court decisions to come down. We know the EEOC's position on this is very clear, and that is that you have to use the individual's preferred pronouns and refer to that individual as they want to be referred to. But that also implicates other rights of individuals, even in a private workplace setting.
Right.
If the government is forcing people to use to sort of accept an ideology that people don't agree with. And so we are sort of waiting for the court decisions on this. The practical advice I could give to people is that I think that using individuals' preferred pronouns is probably a safer approach. And if you don't prefer that approach, then you could simply refer to the person's name over and over. Yeah,
just
instead of
whatever name that is, you call them by the name. Yeah.
Yep, exactly. So a couple other ones real quickly, Phil. I just want to kind of offer this one again out there as a reminder to people that we all know that the Department of Labor issued its new overtime proposal, and there are some significant pieces of this one. Again, I just want to remind everybody the DOL announced the release in late August of its new rule for overtime or exemptions from overtime under the Fair Labor Standards Act, and they're raising that salary threshold, or proposing to raise it from $684 a week or nearly $36,000 a year to $1,059 per week, or about $55,000 per year. Now, what's interesting is analysis of this is coming out, and what this amounts to is this is a 55% increase in the salary threshold, which of course people who are opposed to this increase are arguing this is going to raise the cost of doing business dramatically. And with inflation at 40-year highs, and as millions have dropped out of the workforce, this is the wrong time for the administration to be doing this, according to the opponents of this. And then I think the most significant piece here, though, and this is what I really wanted to talk about this for, is that this proposed rule, according to the analysis that I'm reading from Law 360, says that this proposed rule will turn 3.6 million salaried workers into hourly workers, because they're no longer going to meet that salary threshold. So
that's a lot.
That is a lot. Yeah, and I think also the biggest argument that
you have 3.6 million really mad people.
Yeah,
I mean, I've in almost every case I've had, where the individual's more upset that you're calling them hourly than they are that they're going to get maybe more pay as a result of it. It's a status measurement.
Yeah, I agree with you that is a big issue that's all part of that.
Yeah.
So and then the other piece of it is that the concern right now is, again, what this will do to the economy when you start taking such a large sector of people and increasing the salary threshold by that great of an amount of money. And the previously the Fifth Circuit, I believe it was the Fifth Circuit, when the Obama administration had tried this, actually rejected the Department of Labor's efforts to significantly increase the salary threshold back during the Obama administration, arguing that it was an improper attempt to do so. The fact that it was indexed to inflation arguably makes it illegal. And so this new provision or this new effort by the DOL also looks very similar to that. And so we'll have to see what shakes out once this hits the courts. But I can promise you one thing, it will hit the courts.
Yeah. All right. Well, that's a promise from the great Bert Garland. All right. Thank you, Bert.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.